And I guess the whole reason for the pre-lodgement emphasis is it minimises risk to the process when it's lodged. So if we can be pretty sure we've got a complete application coming in the door, we've done a lot of work with you up front, we're pretty ready to go, and hopefully the 9 months will give us a fair opportunity without information requests overcomplicating things in the middle. So it works for us and it works for applicants. The other part about pre-lodgement is that, in a sense, the RMA part's kind of the easy bit. There's all this other central government stuff that we need to do that isn't explicit within the RMA, that we do behind the scenes that you don't necessarily see. So we prepare a recommendation for the Minister in the event that he may choose to appoint a Board of Inquiry. We need to do all of the work around that, so we need to get nominations from local authorities for who that might be, government departments for potential board members. We then need to check all of those board members for conflicts of interest, availability, eligibility, and put a package together, and all of that has to go to Cabinet and through the State Services Minister, who agrees to board fees. The reason for that is we have to seek exceptional fees because our boards, if we don't seek exceptional fees, we simply can't get board members for the kind of money that we're able to pay. And that really just comes down to the fact that if we are asking you as a consultant to come and sit on a board for us, your daily rate makes you an average of about $1,200 a day when you're offering you 6, as a public service role really. And so we do have to negotiate with the State Services Commission around board fees. And all of that, our recommendation, the Minister's consideration of what he might do with the direction, and the board appointment all has to go to Cabinet. So there's a whole lot of central government process that's going on behind the scenes during that pre-lodgement phase to make sure that when your application comes in the door within 20 days, we've got a recommendation and all of the associated Cabinet papers and briefing notes to the Minister. Okay, so our recommendation. We must identify the relevant factors of national significance, as I've said, and we do have to recommend to the Minister how the proposal should be processed. And that is it appropriate that it comes to a Board of Inquiry or the Environment Court, or should it go back to the local authority for processing? We will put forward the views of the applicant and local authorities regarding process, and in fact we are legislatively required to consult with local authorities on the Minister's behalf to ask them about their capability to process the matter and whether they have a view on whether it's appropriate that it come down the EPA track as opposed to theirs. And we also, as I said, have to accompany a recommendation with a large bundle of documents that need to go to Cabinet and to the Minister. Okay, you may be thinking, Board of Inquiry or Environment Court, what's the difference and why would you choose one over the other? What I can tell you is that historically all but one call-in has gone to a Board of Inquiry, and largely the reason for that is the only one that has gone to the Environment Court had been to the Environment Court previously, and that was the logic behind sending it there. Boards of Inquiry have a minimum of 3 and a maximum of 5 members, and they must include someone who is based locally, someone who has knowledge of tikanga, and a judge. So we work closely with the Environment Court to let them know about what's coming to us so that they have the ability to timetable the potential for where we might be involved and require a judge from them. But we can also use retired judges and High Court judges as well, although we haven't had to do that so much. Boards of Inquiry also tend to be favoured currently, and some of that has to do with the fact that you can have that broader representation than what you may get through the Environment Court. It means we're able, if we've got a geothermal issue, we can get a geothermal expert to sit on the Board of Inquiry, so you have that technical expertise, for example. And also, you've got 5 members rather than 2 or 3, which also assists and shares the load when you've got that tight time frame for decision making. The Board of Inquiry or the Environment Court may commission reports, including independent Section 42A reports. That depends very much on the board's preferences and the issues at hand. Currently, we're processing the Tauhara Geothermal Power Station project proposal, and the board has elected to get a Section 42A planning report. Other boards at times do not. Witnesses may be cross-examined under oath at a board of inquiry, and also the Environment Board. So it's that step up from council hearing, but it's not quite the formality of the court process. And the 9-month timeframe does not apply to the Environment Board. Hence, I think, one of the reasons why boards of inquiry tend to be a more frequent option, because the timeframe is attractive, and it's actually that a lot of applicants are seeking. They want the certainty of having the decision come out sooner rather than later. So, the Minister's direction. As I said, he must consult with Cabinet on the Board of Inquiry appointment and his decision. There's a Cabinet minute that requires that. Once he has made a decision, we have to serve the direction on parties. There's a slightly different wording in the Act. Our provisions in the Act don't talk about affected parties, so our service is not service of affected parties as might traditionally be the case. It's service of those parties who are within and immediately adjacent to the area that the proposal impacts. So that's just slightly different. And it's one area that we do get assistance from local authorities from to obviously identify those parties. And we do publicly notify his direction with the details of the proposal. So it's kind of like double-barreled. You get the Minister's direction plus the public notice that you would traditionally see. And in fact, for the Tauhara proposal, we also publicly notified an indicative timetable and some other information about public meetings and where you could get information and advice about being a submitter. The date of the notification of the direction is the first day of the 9-month process, and from that day forward, the process is independent from the Minister. I think that's a really important point, because I know that I've spoken to people in the community who think that it's a government decision. It isn't. Any decision on these proposals is made by the Board of Inquiry. It is independent. And in fact, if people write to the Minister with issues around the way the board is running or whatever, he just simply refers them back to the board. So it is very arm's length from them. Alright, so let's talk a bit about the EPA's role in the process. What is it that we actually do? We administer the process and we service the board. That's what we're required to do in legislation. So we make board meeting arrangements and we do all the administration for that. And then we also are required in the Act, and it's an EPA function or a board function, to commission what's called a Section 149G3 report, which is a report on key issues from local authorities. That's the piece that's compulsory. So if you're a local authority, you can choose not to work with us on any other level, but you must provide this for us, and we must commission you for it. We also pay for that report from the local authorities. So we enter into a contractual agreement whereby a report will be supplied within a particular time frame. The wording in the Act currently isn't particularly helpful because it really does talk about key issues. And there is a lot of debate in the community at the moment about what that actually means. And so consequently, depending on the issues and depending on whether you're a district or a regional council, those reports can look quite different at this point in time. And probably will do for some time to come until there's some case law for the guidance about that. We look after procurement. So if the Board of Inquiry says, I want to use that expert for a 42A report, it does pose some challenges for us because we are subject to all of the procurement rules of government, which means that we have to go through those procurement processes or seek exceptions in the event that we don't go through those processes. Everything we do obviously has to be transparent, and we work within central government, which means that we are subject to official information requests as well. So people can gain access to everything we do that has anything to do with procurement or our process in particular. We obviously organise the hearing and the administration of the hearing. Our hearings have to be transcripted. They must be located as near as possible to the site of the proposal, so you won't have a situation whereby someone's applied for something for an activity in Taupo and find that your hearing's in Wellington. It doesn't happen that way. Legislatively, we have to have a hearing in Taupo. We are responsible for timetabling. We maintain a website. We try to do everything as far as possible electronically, including service, and we work with our submitters to make sure that that's possible. And also our board members can rely on the website as well for information. We also have an 0800 line. We have a standard 0800 line, but for every proposal that we have, we also have an 0800 line set up for that particular proposal. We try to make it as easy as possible for people to engage with us, recognising that it's not like you can just drop on down to the local council and have a conversation with the local planner. So we are very aware that that can be an issue, and we want to make ourselves as accessible as possible. We cost recover. We have cost recovery delegations for the EPA, but we also have cost recovery delegations from the Minister for cost recovery for boards. So we obviously have to keep our financials in order, and we do all of the work around submissions, receipt and submitter support. And just on that, one of the things that we do around submitters, we do a couple of things. First off, we like to try and do a public meeting about a week after the Minister's direction is notified, because submitters need to understand the process. We don't talk about content, but we do talk about the process. So that submitters right from the get-go, potential submitters or interested public, understand what the process will mean for them, which I think is really important. And with the applicant's agreement, and we've certainly had it in the case of Tauhara, we have a friend of the submitter role. So for the time between the Minister's direction, the first day of the public notice and the 20th working day, we had a planning consultant embedded in the Taupo community with all of the information available, who was able to assist people and advise them on how to make a submission and what the process meant for them. So we try to cover off that local community aspect as well as we possibly can, because we are aware that it's, there can be some concern around that. Okay, so just a little bit more on the 9 months. As I've said, it starts at the date of notification of the Minister's direction. It's 9 calendar months, not working days, which gives us a bit of a complication, because within that, there's a 20 working day circulation period for the draft report and decision. So if you take off the 20 working days for submissions and the 20 working days for the draft report circulation, we've actually got 7 weeks, which makes it very tight. And we're very aware of that. The other issue with 9 calendar months and not working days is that just about everything falls in Christmas sometime. So you've got evidence exchange where you've got the need to start hearings early in January, those sorts of things. That's a bit problematic for us at the moment. But we're very aware of that, and we plan for that and make sure our boards are very aware of that.